Today in this video I am going to share with you some salient features of Immigration, Fiscal Sustainability and System Integrity Amendment Act 2025. So the first primary object as per the New Zealand government to introduce this amendment act is to focus on ensuring that immigration policy supports rather than strains New Zealand's public finances and economy. But means that government has become more greedy. They intend to get more money through more applications from offshore and onshore applicants and finding other resources to generate income, such as imposing levies on employers or education providers. This act intends to give more powers to the Minister of Immigration, even if those powers are contrary to the immigration instructions. And there is another important feature in this Amendment Act, which removes or reduces the status and privilege granted to the holders of resident class visa in respect of liability for deportation as compared to those granted to the holders of temporary visa, section 157 of the Immigration Act 2009. And sufficient reasons under section 157 subclause 5 of the Immigration Act 2009 even does not mention that a person will become liable for deportation if he pleads guilty or has been found guilty of the offending. It only speaks of the criminal offending and other matters relating to the character. Correct. So now speaking about the system integrity, which is the declared objective by the government. So government says that this focuses on restoring trust and confidence in the immigration system by making it less vulnerable to abuse and ensuring it operates as intended. So as per the government, a major consideration in this bill is protecting migrant workers from exploitation by unscrupulous employers. This involves greater penalties for non-compliant employers, more proactive auditing, and ensuring migrants are not tied to a single employer in a way that prevents them from reporting abuse. It is actually criminalizing the employer and employee relationship. There are sections in the current Immigration Act 2009 and there are provisions in the Employment Relations Act 2000 where remedies are available to the labor inspector as well as to the individual employees for taking appropriate legal action against any exploitation or any unresolved personal grievances by the employees. Section 50 of the Amendment Act reads as conditions of resident visas. So after section 54 of the current Immigration Act, there are few subclauses added after 50 subclause 4. So 4A reads, the minister may by special direction in relation to class or classes of persons holding resident visas, A, vary conditions that would otherwise apply to visas of relevant purpose or relevant types or that were imposed under this section that relate to travel to New Zealand. B, vary or cancel conditions that would otherwise apply to visas of the relevant types or that were imposed under this section. 4B, however, the minister may not make a special direction under subsection 4A unless satisfied that the special direction is reasonably necessary to respond to one or more of the following circumstances, which include unusual circumstances, any circumstance that is unable to dealt with under any provisions of the Act, any circumstances that is outside of the department's control, any circumstance that poses a challenge to the immigration system. Or next is 4C, a special direction under subsection 4A may, without limiting the generality of the matter in which persons may be classified, classify persons to whom a variation or cancellation of a visa condition applies by reference to all of the following: their nationality, the country or place from which they are traveling or have traveled, whether it is their original or an intermediate point of departure. C, whether or not they hold or are required to hold any particular type of travel or immigration documentation by whomsoever issued. D, the type of visa that they hold. E, any other type of visa that they have applied for. There is another amendment in section 57 of the current Immigration Act 2009. So after 57(2), there is a subclause 3 now added, which says the minister may by special direction waive one or more of the prescribed requirements for applying for a visa, whether at an immigration control area or otherwise, in respect of a class or classes of persons. So now they are defining that minister has the power to waive off the requirements, right, prescribed requirements for applying a visa, whether an immigration control area or otherwise, in respect of a class or classes of person. So what is section 61? Let us see the first original section. The original section says, number 1, the minister may grant a visa of any type of his own volition to a person who is unlawfully in New Zealand. B, against whom no deportation order has been issued. And C, no removal order has been issued against that person. So, but now section 61A and 61B have been added, which gives more significant powers to the Minister of Immigration. So let's see what 61A says. Section 61A says, number 1, the minister at his own volition grant a visa of any type to a person, first, who is outside of New Zealand, B, is in New Zealand and holds a temporary anti-graft visa. If a person is in New Zealand and holding a valid visa, immigration minister has power under this new act to grant any visa of any type. So now there is another thing, the power is so absolute or unfettered that subclause 2 of section 61A says a visa may be granted under subsection 1 even if the grant is contrary to immigration instructions. Now there is another section added to this 61, which is 61B. So 61B says grant of visas to class of persons by special directions. Number 1, the minister may at any time of the minister's own volition by special direction grant visas of any type. Remember, here word is being any type. Any type, it means it could be even contrary to the immigration instructions, right? So any type of class or classes of persons who are outside of New Zealand or are in New Zealand and hold temporary visas, entry class visas. Second, a visa may be granted under subsection 1 even if the grant is contrary to the immigration instructions. 3, however, the immigration minister may not make any special direction under subsection 1 unless satisfied that the special direction is reasonably necessary to respond one or more of the following circumstances, which are in 54 and 4A to E. Same circumstances, which is unusual circumstance. Second, any circumstance that is unable to be dealt with under the immigration the provisions of the Act. Third, any circumstance that is outside of the department's control. And D, any circumstance that poses a challenge to the immigration system. and a waiver may be made in accordance with subsection 3. So now this is a waiver to be granted by Minister of Immigration, right? So waiver may be made in accordance with subsection 3, may, without limiting the generality of the manner in which the person may be classified, classify persons to whom the waiver applies by reference to all or any of the following conditions. The following conditions are their nationality, their country or place from which they are traveling or have travelled, whether it is their original or intermediate point of departure. C, whether or not they hold, are required to hold, or any particular type of travel or immigration document by whomsoever issued, and D, the type of visa that they hold, and E, any other type of visa that they have applied for. So section 61A and 61B have given unusual powers to the Minister of Immigration. Section 156 speaks about deportation liability if the visa is held under false identity, and there is a minor change in that. 156(1)(a), it says a person is liable for deportation if the person is convicted of an offence. So now new amended section would be a person is liable for deportation if the person is convicted or found guilty or pleads guilty to an offence where the identity is established and that identity is different to the identity under which the person holds a visa. So similarly, in section 158, which is about deportation liability of residence class visa holders due to fraud or forgery, etc. In section 158(1)(a), the same things would be replaced. Where there is a word says convicted, it will be found guilty, convicted, found guilty, or pleads guilty. Deportation liability of residence class visa holders convicted of criminal offence. So in this heading, the word will be changed to convicted or found guilty or pleads guilty. So that will be added into this heading. And now section 2, which says residence class visa holder is liable for deportation if he or she is convicted in New Zealand or elsewhere. So the words after convicted would be found guilty or pleads guilty. So that will be added here. So now you will learn that Immigration Amendment Act has brought another new clause or new section, which is called 351A. So we will come to that section 351A in a minute, but let's go to section 173. It has also been amended with a minor changes. So section 173 says right of victims to make submissions on suspension or cancellation of liability for deportation. So section 173 as it stands today, it says number 1, in determining whether to cancel or suspend a person's liability for deportation, the minister must have regard to any written submissions made by a victim of an offence or offshore offences of which the person who is liable for deportation has been convicted. So where the word convicted is there, two more words, found guilty and pleads guilty, will be added. There is after section 351, there is a section called 351A. So subsection 1 of this new act, new section, subclause 1 says every employment related person. Now there are so many new words coming up which we will describe and we will discuss in the later part of this video. There are few words which you need to note in the inverted commas. So the first is employment related person commits an offence against this act who, whether in or outside New Zealand. So now there is another inverted commas, in or outside New Zealand. First is every employment related person, that is first inverted commas, first quote. Second is in or outside New Zealand. Seeks or receives. Seeks means demands or wants, or receives any premium in respect of the employment or potential employment. So another inverted commas word, potential employment in New Zealand of a victim. So this is subsection 1 of section 351A. Now 2, subsection 1 applies A, before and after the victim commences work in New Zealand. It says even if the worker or the victim has not even commenced his employment, still this subsection 1 will apply. Definitions, right, because there are few words which I referred you before, that what is a victim, right, who is a victim. Second, who is a employment related person, right. So then thirdly is who is overseas based or who is New Zealand based. So in this section, a person is a victim if they are domiciled in New Zealand. So person can be a victim if they are living in New Zealand, domicile means living in New Zealand, or are overseas based. So secondly, they must be either overseas based and must fall under the following categories. So what are those categories? A, he can be an unlawful worker. So a person who is in New Zealand, living in New Zealand, but unlawfully working, so that person can also be considered as a victim. B, a temporary entry class visa holder. So if a person is on a student visa or a visitor visa or partnership based or any other category of visa, but he must be on a temporary visa, that person can be considered as a victim. So first, a person who is unlawful in New Zealand. Secondly, a person who is holding a temporary entry class visa in New Zealand, or a potential temporary entry class visa holder. Now potential word has been added in this section as well. So potential means he is currently not a temporary entry class visa holder, but he wants to. So potential means he might be. So it's and lastly, a potential residence class visa holder. A person who is not even in New Zealand can trigger the section 351A, which is a new added section, and the immigration officer will get jurisdiction over a victim who is not in New Zealand and who is based overseas. So now moving forward, in this section, which is now subsection 5 of 351A, subsection 5 says the definitions of different category of people, which I referred in the beginning of this section. So employment related person, what does that mean? So it says A, employment related person means a New Zealand based employer or potential employer of a victim. So even if a person, the employer has not given the employment to the victim who is overseas based, still that employment related person can be prosecuted in New Zealand under section 351A. So that is the implication of this definition, that employment related person means an employer or a potential employer. So potential employer means who has not even offered the employment, who was going to offer the employment to a person who has not even established a relationship with the victim, can be prosecuted under section 351A, which also makes this clause draconian. Now B, a New Zealand based agent of an employer or potential employer of a victim. C, a New Zealand based person involved. Now there is another person which has been added as in the list of offenders, potential offenders I would say. So first was employer, New Zealand based employer or potential employer. Third, agent of the New Zealand based employer. Then coming another one, New Zealand based person involved in the recruitment of a victim for employment or potential employment in New Zealand. So first was employer, potential employer, agent, and now New Zealand based person involved in recruitment. So it could be even a recruitment agent, it could be unlicensed recruitment agent, or he could be a person involved. So person involved could be anybody, the relative of the victim, the relative of the employer offender, if that person is in New Zealand. So lot of people can be brought within the jurisdiction of this section 351A. Now another category of the offender, a New Zealand based person who has dealt with a victim in the context of the victim's employment. So now there is another person who has dealt with the victim. So he may not be an agent, he may not be a relative, he can be stranger to the victim or stranger to the employer, but if he is a person involved or he has been dealt with a victim, so it is a person who has dealt with the victim, even though that person would not have any relationship or any link or connection with the potential employer or the employer in New Zealand, still a person who has dealt with the victim can attract penal action under section 351A. So it doesn't say that that person, the last category of person, must be linked or connected with the employer in New Zealand. It could be any stranger who has dealt with the victim who is either in New Zealand or overseas. That person can be prosecuted who has dealt with the victim in the context of providing victim's employment or potential employment. Moving forward, New Zealand based person. So what is New Zealand based person means? So a New Zealand based person is who is a New Zealand citizen or domiciled in New Zealand, whether or not he holds a visa, he or she holds a visa. So even if a person is a New Zealand citizen, they can be prosecuted under these 351A, and the person who is in New Zealand may be living lawfully or unlawfully. So even if a person is living unlawfully and falls within these four categories, I will repeat those four categories now: employer or potential employer, agent of the employer, and then a person involved in the recruitment of the victim, then the person who has dealt with the victim in the context of providing victim's employment or potential employment in New Zealand. So now New Zealand based person could be a person who is unlawful in New Zealand, or who is in New Zealand lawfully, or is a New Zealand citizen. Now overseas based person. So what is the meaning of overseas based person? That is also been defined in the this section 351A(5). Overseas based person who is not New Zealand based. So even if the person is not present or not living in New Zealand, that will be considered as an overseas based person, and that person can be a victim as well. Now potential residence class visa holder. So potential residence class visa holder means who seeks to hold a residence class visa. Seeks means who intends or who wishes or who wants to hold a residence class visa, and he seeks to obtain employment in New Zealand. So the first thing would be potential residence class visa holder, he should be intending or requiring residence class visa, and secondly he seeks to obtain employment in New Zealand and is required to be employed in New Zealand in order to be granted a residence class visa in accordance with immigration instructions. So this is the three categories of the person who can be potential residence class visa holder. Now potential temporary entry class visa holder means a person who seeks to hold a temporary class visa or to obtain employment in New Zealand. Now temporary entry class visa holder means a person who holds a temporary entry class visa. Now unlawful worker means a person who undertakes or seeks to undertake, so who is working unlawfully or who is intending to work unlawfully. Seeks to work unlawfully means seeks means requires or he is intending to undertake work that person is not entitled under this act to undertake. So he seeks to undertake a work which he is not entitled to undertake. So that person can also be considered as an unlawful worker. So unlawful worker is a victim under section 351A.